Chapter 4, The Indian Constitution. Introduction. Though the Indian society is pluralistic, it is united at the time of any foreign threat. In India, the person from any religion can become the Prime Minister and the President. At the time of any natural calamity, the people of India help each other. The people enjoy their human right freely. This is only possible because of a great constitution. Otherwise, in our neighboring countries, we see that prime ministers, presidents are imprisoned, governments are overthrown by militaries, and political powers are captured by anti-social elements. In India, due to constitution, we as Indians remain united, follow patriotism, and maintain national unity and integration. Hence, Indian constitution as a unifying factor in Indian society must be studied properly. Making of Indian constitution. We have the history available about the constitutional developments in India. For example, Morley Minto reforms, 1909, Monte-Chelmsford reforms, 1919, Indian Independence Act, 1935, etc. In 1946, there came the Cabinet Mission Plan, which provided for the formation of Constituent Assembly to prepare a constitution for India. The members for the Constitutional Assembly were elected from the provincial legislative assemblies. These members were selected from three groups: General, Muslims, and Sikhs. They were selected by proportionate representation. There was also the representation given to the minority and depressed classes communities like SCs, Parsis, Indian Christians, Anglo-Indians, tribals, and even women too. The members were the persons with talent and ability. The Congress, the Indian National Congress, won 208 seats. Muslim League 73, and remaining from other categories. The Constituent Assembly consisted of 389 members, out of which 296 were from British India and 93 from princely states. Muslim League refused to join the Constituent Assembly. The first session of the Constituent Assembly was held on 9th December 1946 under the provisional chairmanship of Sachinand Sinha. There were 207 members present at the session. On 11th December 1946, Dr. Rajendra Prasad was elected as the permanent president of Constitutional Committee or Constitutional Assembly. Constituent Assembly passed certain rules about the formation of the drafting of the Constitution. Therefore, to prepare the draft Constitution, drafting committee was formulated, and on August 29, 1947, Dr. B.R. Ambedkar, a legal luminary and a constitutional expert, was appointed as its chairman. Dr. B.R. Ambedkar put all his energy and efforts to prepare the constitution. The draft was completed on 26 January 1949. This draft was kept for discussion and suggestions for 8 months, from 21st February 1948. Before the public and Constituent Assembly, it took 2 years, 11 months, and 18 days to complete the Constitution. From 26 January 1950, the Constitution came into force. Philosophy of the Constitution. The Objective Resolution. The preamble of Indian Constitution is the most important part, which incorporates together the fundamental rights and directive principles as well as the aims and ideals of the Constitution. The philosophy of the Constitution is nothing but values, ideals, aims, objectives, etc. as the foundation on which it stands up. The first session of the Constituent Assembly was held in New Delhi on 9th December 1946 under the provisional chairmanship of Dr. Sachinand Sinha. On 11th December 1946, Dr. Rajendra Prasad was unanimously elected as the President of the Constituent Assembly. On 9th December 1946, Pandit Jawaharlal Nehru moved the Objective Resolution, which was unanimously acclaimed and adopted on 22nd January 1947 by the Constituent Assembly. The Objective Resolution reflected high ideals and philosophy, which inspired the shaping of the Constitution of India through all its subsequent stages. These ideals and philosophy embodied in the objective resolution are truly reflected in the preamble to the Constitution of India. This objective resolution was based on the concept of an India emerging as a sovereign republic with its power and authority derived from people, wherein social, economic, and political justice was to be guaranteed and secured to every individual, as also equality of status and opportunity to everyone. It was a firm resolve and a pledge to build a sovereign, democratic republic in India. Content of Preamble. The preamble means preface, preliminary statement, or an introduction to any literary work or scholarly work. It is the beginning remarks which takes the readers and the executors of the instructions towards guidance to performance. The preamble to the Indian Constitution reveals the minds of the Indian society through a divergent in nature. It reflects the sustaining goals of the Indian polity, and the ideals are sought to be achieved through the medium of the Constitution. The preamble begins as follows: We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution, added by 42nd Constitutional Amendment Act 1976. Now, we have to elaborate the preamble word to word as per its conceived values, ideals, objectives, and philosophy. We, the people of India, means it is the people of this country adopt and enact the Constitution, a legal body for themselves. On behalf of the people, the founding fathers and chief architect of the Constitution, Dr. B.R. Ambedkar, prepared this document of Constitution. They are not themselves adopting and enacting, but the people are the major body to frame the Constitution. They are the representatives of the people, and it's people who are resolving to constitute India. Sovereign, socialist, secular, democratic republic. The people of India constitute India into sovereign nation. The term sovereign means free from any internal or outside control. It suggests that the Constitution is not the gift of the British Parliament, and the people of India are capable of framing the legal body of their own for themselves. For this purpose, they have sent their representatives to the Parliament, that is, the Constituent Assembly. There is no any limit or any restrictions on the people of India to frame the Constitution for themselves. The term socialist was not the part of the preamble in 1950, but was inserted in it by the 42nd Constitutional Amendment Act 1976. Socialist means that the Indian masses aim to build an egalitarian society in India, prevent concentration of wealth, bring about social control over means of production, and ensure equitable and fair distribution of necessities in life. This term is related to the socialism of Marx, but in partial ways. Every citizen will have the right to earn his livelihood and also improve his standard of living. The term secular also was not the part of the preamble in 1950. By the 42nd Constitutional Amendment Act 1976, it was inserted in the preamble. The term secular emphasizes the fact that the Indian state does not have any state religion and grants complete freedom of worship and faith to all its citizens. It does not encourage or discourage or discriminate against any particular religion. It indicates the fact that the state is neutral in all religion matters and the right of citizens are independent of the faith they profess. The spirit of secularism is fully reflected in Article 25th of the Constitution, which ensures freedom of conscience and right to freely profess, practice, and propagate one's own religion. According to former President of India R. Venkata Raman, secular India means India is not pro-religious, non-religious, and anti-religious. The term democratic, in the narrow sense, refers to the form of government which is elected by the people on basis of universal adult franchise. In a broader sense, it refers to a way of life of the people and numerous social organizations. Indian government is based on a representative parliamentary democracy in which the government is responsible to the sovereign legislative body. There are various forms of democratic government such as presidential, which is in US, kingship, which is found in England, Australia, New Zealand, and parliamentary democracy, of which India has adopted parliamentary form of government. The term republic stands for that the head of the Indian state will be elected head and not the hereditary ruler by kingship. It also means that the supreme powers of the state are vested in the people and in the authority of the elected representatives of the people. The term republic also implies that all public offices are open to all citizens without any discrimination. Justice, liberty, equality, and fraternity. Further, the preamble lays emphasis that the Indian citizens should get justice in three forms, such as social justice, economic justice, and political justice. The architects of the constitution has made this arrangement of justice very intelligently. There cannot be economic justice and political justice without social justice. Indian society composed of caste, classes, religion, race. There happened the discrimination among Indians among themselves on these bases. Therefore, the constitution is bound to cultivate healthy social attitude among people and the state must be welfare state accordingly. The social justice can be realized only when equals to be treated equally and unequals unequally according to Aristotle. The next step of justice which preamble secures for the Indian people is economic justice. Every citizen of India has the right to live and earn his livelihood. They must be made available employment opportunities taking in view social justice. The directive principles of state policy make it clear that no discrimination would be made between persons on basis of their economic status. The state is expected to enact laws and translate the concept of social and economic justice into reality. Political justice is only possible when there is realization of social and economic justice. Previously in India and many countries of the world were giving voting rights to only those who are rich by wealth, but the Indian constitution has conferred on all the Indian adult citizens the universal adult suffrage without any discrimination of caste, race, religion, sex, wealth, status, etc. The Indian citizens have got one vote and one vote, one value, which is very significant for political justice. Thus, the concept of social, economic, and political justice contained in the preamble aim at furthering the goal of social revolution and attempting to foster this revolution by establishing the conditions necessary for its achievement. The preamble contains that liberty is secured for the Indians, which is of thought, expression, belief, faith, and worship. The Constitution of India secure for its citizens the liberty that everyone without any bias will have the right to think and express his own views, which will not harm others' liberty. They can convert to any religion, can worship any god and goddesses, or believe in any kind of philosophy they want. That is how the 6 kinds of freedoms are provided in the article number 19 of the Constitution. The preamble makes mention of the equality for all citizens of India without any kind of discrimination. There is 2 kinds of equalities, such as equality of status and equality of opportunity. Every citizen of India would be treated equal before law irrespective of his caste, religion, race, sex, language, etc. As well as he shall get equal opportunity to make his economic progress. It also made clear as per the Article 16(4) that states shall have right to enact laws and make provision for reservation of jobs or posts in favor of any backward class of citizens. This provision also promotes the cause of justice by providing protective discrimination to those classes of people who have suffered due to historical circumstances of casteism. This is what unequals to be treated unequally, that is justice. The preamble also provides the Constitution is bound to promote among the Indians the fraternity which assures the dignity of the individual and the unity and integrity of the nation. In the words of Chief Architect of the Constitution, Dr. B.R. Ambedkar, fraternity is a sense of common brotherhood and the principle which gives unity and solidarity to social life. He further says, without fraternity, equality and liberty will no longer be deeper than coats of paints. Therefore, one has to take liberty, equality, and fraternity not as separate objectives, but as forming a union of trinity, in the sense that to diverse one from the other was to defeat the very purpose of democracy. All the above provisions further the people of India to adopt, enact, and provide in the Constitution, which is approved by the Constituent Assembly on 26th November 1949. The structure of the Constitution, the preamble, main body, and the schedules. The structure of the Constitution is divided into the preamble, the main body, and the schedules. The main structure of the Constitution cannot be changed totally as there are provisions of amendment to it. The Indian Constitution contained 395 articles and 12 schedules. In this structure, each and every provision has been discussed thoroughly and then it got passed in the Constituent Assembly. The Preamble. The preamble is the mirror of the aspirations of the people to themselves, which reflects into it. The preamble is not the part of the articles, but it is the gist of all the provisions elaborated in all the articles. It is a philosophical commitment which would be realized into practice by the government and its state. It is the sum total of the Constitution. We already have discussed the philosophical component of the preamble. Main body of the Constitution. The main body of the Constitution of India consists of 22 parts, 395 articles, and 12 schedules, and they have been elaborated thoroughly in these provisions. Parts of the Constitution. Part 1. The Union and its territory. The Part 1 consists of articles from number 1 to 4. Article number 2 deals with name and territories of the Union and establishment of new states. Article 3 mentions about the provisions of formation of new states and alteration of areas, boundaries or names of new states. Article 4 provides the amendment of the first and the fourth schedules and supplemental, incidental and consequential matter pertaining to article number 1 and 3. Citizenship. The part 2 consists of article number 5 to 11 in regard to citizenship. Article 5 relates with the citizenship at the commencement of the Constitution. Article 6 to 11 provides for rights of citizenship for migrants to and from Pakistan or outside India and the right of the Parliament to continue and regulate it. Fundamental rights. Part 3 deals with fundamental rights for Indian citizen elaborated in the article number 12 to 35. The fundamental rights are the right to equality, right to freedom, right against exploitation, right to religion, cultural and educational rights, and right to constitutional remedies. The right to property was deleted by the 44th Constitutional Amendment Act 1978. Part 4. Directive Principles of State Policy. It includes article from 36 to 51 wherein the Constitution has directed the state to be welfare state and execute the values, principles of equality, liberty, justice, social justice, health, industrialization, education in general and of weaker sections etc. Thought of the government cannot be pulled into the court for violation of the directive principles but is also taken as a duty of the government as to become the welfare state. Due to fear of not getting elected again, government has to do public works continuously and is elaborated in their part. Part 4. Fundamental duties. In 1950s, Originally, the Constitution did not contain separate fundamental duties for the citizens of India, as it was natural that everybody respect everybody's fundamental rights. But by 42nd Amendment Act 1976, it was separately provided for the 11 fundamental duties for the Indian citizens. Part 5. The Union. The Part 5 contains 5 chapters related to individual subject. Chapter 1 is titled as The Executive and contains articles from 52 to 78. Articles 52 to 73 deals with the powers and functions of the President and Vice President. Articles 74 and 75 provides for the formations of Council of Ministers and its functions. Article 76 makes provisions of appointment of powers, functions of Attorney General of India. Article 77 and 78 pertain to the conduct of government business and functions and duties of the Prime Minister. Chapter 2 is titled as Parliament and contains articles from 79 to 122. Articles 79 to 88 deals with formation and constitution of Parliament. Articles 89 to 98 provides for the officers of the Parliament. Article 99 to 100 deals with the conduct of business of the Parliament. Articles 101 to 104 makes the mention of disqualification of members and the vacant seats. Articles 105 and 106 deals with powers, privileges and immunities of Parliament and its members. Articles 107 to 111 provides for the legislative procedures of the Parliament. Articles 112 to 117 are related to the procedure of Parliament in financial matters. Article 118 to 122 provides for the procedure generally of the Parliament. Chapter 3 is titled as Legislative Powers of the President. In this chapter, Article 123 explains the powers of the President during the recess of the Parliament to promulgate ordinances. Chapter 4 is titled as the Union Judiciary and contains Articles 124 to 147. These articles provide for the composition, powers, and jurisdiction of the Supreme Court of India. Article 143 mentions the powers of the President to consult Supreme Court. Chapter 5, titled as Controller and Auditor General of India, contains articles of 148 to 151 and elaborates the appointment, duties, powers of CAG, which is Controller and Auditor General of India. Part 6. The States. This part contains 6 chapters and articles from 151 to 237 regarding the state level provisions. Chapter 1 is pertaining to general, wherein 152 defines the state and its limits. Chapter 2 is titled as the executive and lies in the articles from 153 to 167. Article number 153 to 162 elaborates the governor, its appointment, powers and functions. So far, articles 163 and 164 details about Council of Ministers. Article number 165 provides for the Advocate General of the state. Article 166 to 167 deals with conduct of government business in states, duties of chief ministers, etc. Chapter 3 is titled as the State Legislature and contains articles from 168 to 212. Article 168 to 177 explain in the General Constitution of Legislature in states, Legislative Assembly and Legislative Council. Articles 178 to 187 talks of the officers of the state legislature such as the Speaker, Deputy Speaker of Assembly, Chairman and Deputy Chairman of the Council. Articles 190 to 193 elaborates the disqualification of members due to vacation of seat or any other reason. Articles 194 to 195 for the powers, privileges, etc. of the houses of legislatures and their members. Articles 196 to 201 explains the legislative procedure such as passing the bill, etc. Whereas Articles 202 to 207 provide for the procedure of the legislature in regards to financial matters. Articles 208 to 212 deals with the procedure generally wherein rules are explained. Chapter 4 titled as Legislative Powers of the Governor, which have been explained by the article number 213, for example, power of governor to promoting audiences during the recess of the legislature. Chapter 5, titled as the High Courts in the States, contain Article 214 to 231, which provides for the appointment, powers, and jurisdiction of the High Courts in the states. Chapter 6, titled as Subordinate Courts, contain Article 233 to 237 and detail about the appointment, powers, and jurisdiction of the district and subordinate judges. Article 232 has been repealed from the Constitution. Part 7 also have been repealed as per Article number 238 and 7th Constitutional Amendment Act 1956. Part 8 The Union Territories. This part contains Article 239 to 242 and elaborates the administration of the Union Territories, special status to Delhi, the powers and functions of President and the High Court, etc. Part 9 The Panchayats. This consists of Article 243 and explains the constitution of Panchayat Raj, local self government. It also provides for the constitution of municipalities and its powers and functions. In the same sub article, there is a provision of Finance Commission. Part 10. This contains Article 244, which in we find the provisions of the administration of scheduled areas and tribal areas as in Assam. Part 11. This is titled as Relations between the Union and the States and contains two chapters. Chapter 1 states as the legislative relations and consists of articles 245 to 255. They provide for the powers and parliament and the state legislature. Chapter 2 elaborates the administrative relations between the union government and the state government. Between Articles 256 and 263, it has a detailed explanation about the disputes relating to water and coordination between the states and the role of the union. Part 12 Finance, Property, Contracts, and Suits. This part has 4 chapters and contains Articles 264 to 300. Chapter 1 is related to the finance from Articles 264 to 267. Provides with general such as taxes, consolidated funds, contingency fund, and public accounts. Article 268 to 281 makes the mention of distribution of revenues from the union and the states. Again, Article 280 provides for Finance Commission. Articles 282 to 290 are related with miscellaneous financial provisions. Chapter 2, titled as Borrowing, and consists of Articles 292 and 293 and mentions the borrowing by the Government of India and the state. Chapter 3, titled as Property, Contracts, Rights, Liabilities, Obligations, and Suits, and contains articles between 294 and 300. It provides for the succession of property assets, rights, liabilities, and obligations, as well as contracts and suits and the proceedings. Chapter 4 is titled as the Right to Property, where article number 300 provides that a person should not be deprived of property and should be saved by the authority of law. Part 13 is titled as Trade, Commerce, and Intercourse within the territory of India. This part contains from Articles 301 to 307, wherein provisions are made for the freedom of trade, commerce, powers of the Parliament to impose restrictions, etc. Part 14 is titled as Services under the Union and States and is divided into two chapters. It consists of Article 308 to 323. Chapter 1 in the Article 308 to 314 provides for the recruitment and conditions of services of persons serving the Union or a state. Chapter 2 is titled as Public Service Commission, where between the Articles 315 to 323 it makes provisions for the UPSC and State Public Service Commission and its functions, etc. Part 14 and its Articles 323A and B are provisions of administrative and other tribunals. Part 15, titled as Elections, and lies between Articles 324 and 329. Part 16 is titled as Special Provisions relating to certain classes. Part 17 is titled as Official Language and has 4 chapters from Article 343 to 351. Part 18 is titled as the Emergency Provisions and contains from Articles 352 to 360. Part 19 is titled as Miscellaneous and contains Articles 361 to 367, in which provisions of protection of President and Governors have been made. Part 20 is titled as Amendment of the Constitution, wherein only Article 368 is provided for the power of Parliament and to amend the Constitution. Part 21 is titled as Temporary, Transitional and Special Provisions and lies from Articles 369 to 391. Part 21 is titled as Short Title Commencement Authoritative Text in Hindi. Fundamental Duties of the Indian Citizen. Basically, fundamental rights always correspond to the fundamental duties of each and every citizen, and therefore, the founding fathers of the Constitution must have had specified them. But one individual knows or enjoys his fundamental rights at the same time others also do and show respect for them. That is their duty. In 1976, there was a 42nd Constitutional Amendment Act, which was called as the Mini Constitution by some experts. Article 51A provided the fundamental duties of the Indian citizens, which are as follows: 1. To abide by the Constitution and respect its ideals and institutions, the national flag and the national anthem. Second, to cherish and follow the noble ideas which inspired our national struggle for freedom. Third, to uphold and protect the sovereignty, unity, and integrity of India. Fourth, to defend the country and render national service when called upon to do so. Fifth, to promote harmony and the spirit of common brotherhood amongst all the people of India, transcending religious, linguistic, and regional or sectional diversities, to renounce practice which are derogatory to the dignity of women. Sixth, to value and preserve the heritage of our composite culture. Seventh, to protect and improve the natural environment, including forests, lake, rivers, and wildlife, and to have compassion for living creatures. Eighth, to develop the scientific temper, humanism, and the spirit of inquiry and reform. Ninth, to safeguard public property and to abjure violence. 10th, to strive towards excellence in all spheres of individual and collective activity so that the nation constantly rises to higher levels of endeavor and achievement. 11th, who is a parent or guardian to provide opportunities for education to his child as the case may be, ward between the age of 6 and 14 years. This was provided in 2002 by the 86th Constitutional Amendment Act with reference to Article 45. These fundamental duties are sometimes criticized and sometimes favored by the various constitutional experts. Values of tolerance, peace, and communal harmony. Indian society is pluralistic in nature and therefore it faces always differences and divergences of opinion in matters pertaining to religion, caste, race, color, sex, region, languages, etc. But our Indian constitution is the only fabric that weave all these differences together and strengthen it. Apart from this, there are some values to be inculcated among the children and youth and the Indian citizens into such tolerance, peace, and communal harmony. Therefore, we will discuss these values as follows. The value of tolerance. Tolerance can be defined as the sense of understanding of others' feelings and having respect for others. In India, as a multiplicity of religions, caste, creeds, regions, languages, tolerance is very significant value which all the Indians must cultivate among themselves. In this composite society, one must bear with other people's opinion. One has to have the understanding that divergent opinions are the common phenomena in a country like India, and hence, though the opposite views expressed by any person has to be listened carefully, it has to be countered peacefully. Importance of tolerance. Tolerance is necessary value to understand the nature of the individual. Tolerance leads the person to behave in the society with compromise and adjustment. Tolerance can stop quarrels and conflicts among people and establish peace. The composite society like India is a prime requirement to strive for harmonious relationships, and hence only tolerance can maintain it. Tolerance helps the democratic society to flower and flourish. It also inculcates liberal thinking in the person about the differences of opinion. Person can have respect for other viewpoints though they are opposing to his own beliefs. If we want India to prosper economically and become world power, tolerance is the important value to be attained. Tolerance can establish equality between human beings and allow to enforce constitutional provisions. Tolerance can help reduce interconflict like communism, communalism, casteism, linguism, and regionalism, and lay communal harmony as a possible goal of the Indian Constitution. Therefore, tolerance can promote national integration, establish national unity, and inculcate patriotism among the citizens. Value of peace. To strengthen the social fabric of the Indian society, there should be a peaceful cooperation among several members. The cooperation and mutual help leads to people to think towards peace. The peace is an essence of progress. In community life, we must lift equal share of responsibility and carry it willingly. We should help each other in the natural calamity or in difficulties by human beings in circumstances irrespective of their caste, creed, sex, region, language, etc. When everyone is cooperative, the social and other group activities will always bring the best, and therefore proper understanding and mutual cooperation is the soul of any group activity, though it is pluralistic. Peace is essentially a moral and human value and requisite of Indian society. Whenever anything goes against one's interest or desire, one should not resort to physical violence but should follow constitutional ways. Survival of the fittest or might is right are the phenomena applied to animals and not to the human beings. If the violence and force have their way every time, then weaker, old, sick, handicapped, and other sections of the society will find their survival impossible. When you are following peaceful life, so will others. In Indian composite culture, peaceful coexistence is very significant. By the virtue of peace, we can avoid communal riots, violence, and lead a harmonious life. Basic features of the Indian Constitution. The founding fathers of our Constitution studied various constitutions available in various countries of the world and picked up selected principles which would be suitable to the Indian socio political, economic, cultural, and religious conditions. The Constitution of India has provided the Indian citizen the best of the things for leading a happy and peaceful life. Therefore, the basic features of it are as follows. Preamble, the lengthiest written constitution in the world. When Indian constitution was prepared, it had 395 articles, 9 schedules, and 12 parts. It is most detailed written document. The US constitution has only 7 articles. The Australian constitution has 128 articles and the constitution of Canada has 147 articles. Indian constitution gives the details of administrative, machinery, execution, legislation and implementation details of the judiciary. The country, like England, has no written constitution at all. According to the Constitutional Amendment Act number 92 in the year 2003, the Indian constitution is consisted of 447 articles, 12 schedules and 26 parts. Popular sovereignty. It is clearly stated in the preamble of India that India is not under any outside control. It is a sovereign nation under the people. The people will have the right to elect their representatives to rule for themselves to the government. Hence, India has a democratic system of government. Any citizen who is above the age of 18, irrespective of religion, creed, caste, region, property, rich or poor, man or woman, can execute adult franchise and have his representative for his/her welfare. It is very of significant provision in Constitution that the person may be from dire poverty or from an industrialist will have right to one vote and one vote will have one value. Therefore, popular sovereignty is very important feature of the Constitution of India, partly rigid and partly flexible. When we read a constitutional document, then we come to know that sometime, somewhere, the articles of the constitution are very rigid to make any amendment, and somewhere, some articles are very easily amended according to the situation exist. The Article 368 of the constitution provides for the amendment. At the same time, in case of Jammu and Kashmir, the parliament has got limited rights to intervene in the affairs of the state. As against this, during 57 years, there are 92 amendments which have been made in the constitution, and states like Nagaland, Sikkim, Jharkhand, Chhattisgarh have been newly created. Many articles are added according to the present context. Provision of fundamental rights. The Constitution of India guarantees the fundamental rights to every individual, irrespective of birth, caste, creed, sex, religion, race, language, region, age, education, rich, poor, etc. Articles from 12 up to 35 mentions of fundamental rights. They are as follows: right to equality, right to liberty, freedom of speech and expression, freedom of assembly, freedom of practice of any profession or occupation, freedom of union or professional organization, freedom of staying anywhere in India, freedom of move anywhere in India, freedom of religion, right against exploitation, cultural and educational rights, right to constitutional remedies, habeas corpus, mandamus, prohibition, quo warranto, and certiorari, the independent judiciary. The Indian Constitution, among its three major bodies of legislature, executive, and judiciary, have more rights and freedoms given to the judiciary. The rules and laws and regulations regarding the appointments and rights and powers of the judiciary, that is, the Supreme Court, High Court, and subsequent courts and their judges, have been clearly stated in the Constitution. The judiciary have been kept out of the purview of the legislation and the executive body. The judgment given by the judiciary becomes the law. The judicial review. The Supreme Court and the High Court are the guardians of the Constitution. They also have got the right to interpret the provision of the Constitution. Therefore, government before passing any act or any law undergoes investigation to the Constitution and takes care that there would be no violation of the constitutional provision. It happens sometimes that the Parliament, Councils, and Assembly may be wrong in passing any act against which one can act and ask the courts of law to review the decision taken by the government. The Supreme Court and the High Court can declare such law null and void or unconstitutional if it goes against the constitutional provisions. End of the old order and rise of the new order. Our Indian Constitution is revolutionary in the true sense of the term. Since ancient times and for thousands of years, the power was administered by the provision of Manusmriti. Instead, now it runs with the provisions of the Constitution. Constitution guarantees equality, liberty, fraternity, justice, equal opportunity, etc., which were denied to certain section of the society in the old times. The Constitution has abolished untouchability and termed it as an offensible punishment. It also protects women, children, and historically deprived or depressed classes. Hence, the old order of Manusmriti has gone and the new order of the Constitution has risen. Adoption of good principles from others. The architects of the constitutions knew the constitutional provision of the many countries. Hence, after lots of study, they adopted certain good principles from the constitutions of other nations of the world. They are as follows. From England, they took parliamentary democracy and the election process. From America, they took judicial review. From Canada and US, they took federal nature of the state. From Ireland, they took guarding the principles of the state policy. From England and France, they took president and his powers. From US and France, they took fundamental rights. From South Africa, they took amendment and flexibility. From German Weimar Republic, they took the emergency. Summary. The Constitution of India is a very important document. It guides the administrators continuously about the legal advice. It provides liberty, equality, and fraternity with social, eco political justice and opportunity. The Constitution also guarantees to the fundamental rights as well as it provides for the fundamental duties. It is a constitutor that is helpful in maintaining communal harmony, peace, and law and order. The implementation of democracy and guidelines principles is only possible due to constitution. Therefore, we have to regard the constitution as a sacred document of India. Questions 1. Describe the process of making Indian constitution. 2. Explain the structure of Indian constitution. 3. Elaborate the fundamental duties of the Indian citizen. 4. Review the basic features of our constitution. Unit End.